Go right ahead.
Good morning, Your Honors. Catherine Knudsen on behalf of Nikki Fuller, Susan Fuller, Quilbillies, LLC, and William Stern, the sole member. My clients are in the courtroom today. We're here on appeal of the district court's ruling dismissing all of my clients' claims, contractual, extra-contractual, failing to permit additional discovery, and failing to certify certain issues to the Washington State Supreme Court. I'm going to start with the breach of contract claim unless there's some, or the duty of good faith, unless there's somewhere else you'd like me to start, because there's a lot of issues. Okay. People buy insurance to protect things that they care about. Here, my clients bought insurance and paid their policy to protect the land that their homes sit on. They're out in a peaceful area by Hood Canal. What happened was neighbors purported to exercise an easement right that cuts right through their land. The trial court in First American began and ended their analysis on the Batdorf case, and they applied that to all of the claims, the extra contractual and the contractual. That was an error. Insurance policies in Washington, there is a plethora of case law supporting this in my materials. Insurance companies in Washington owe much greater duties than just the promises that they make to pay benefits in their insurance policies.
So that's certainly true if we're talking about liability insurance. Could you focus on title insurance?
Sure. Well, I'll say that this duty of good faith applies to every type of insurance policy. In Washington, there are certain carve-outs for the Washington claims handling regulations for healthcare carriers. That's it. These principles of good faith claims handling apply across liability policies, malpractice policies, title policies, homeowner policies, UIM policies, Tank, Coventry, all of those cases apply here.
What I'm struggling with is that the district court ruled that this particular policy gave the insurance company the right to do exactly what it did. So he didn't find bad faith. I'm paraphrasing, but can you speak to that? What about this policy and what the choice that it provided to First American?
Yes, exactly, Your Honor. The obligation, the choice that they made, there's one issue, which is the breach of contract. Did they fulfill the contract terms? Were they allowed to make that option without providing any defense? That's separate. When we're talking about the duty of good faith, we're talking about the insurance company's conduct and behavior in exercising that decision and making that decision. Stern made a claim, said, "Hey, I want help with this." In September 2021, said, "I want you to help me mediate this." He made a claim. Okay, he made a claim asking for legal help to deal with this claim. That triggered the insurance company's obligation to treat him fairly, to comply with the WACs, to not put, when Susan Fuller's claim comes in later, but the insurance company at that point owed a duty not to put its own interests above those of the insureds. It had a duty to perform an investigation into the claim. It had a duty to not act unreasonably. There is a broad scope of behavior that gives rise to bad faith claims.
So let me just make sure I understand your argument. Number one, under Batdorf, they could pay up and resolve the contract claim. Is that right?
Under Batdorf, so first of all, Batdorf does not address extra contractual claims or bad faith at all.
That's not my question.
Yep. And
my question is very clear.
On the breach of contract, yes.
That resolved breach of contract. Okay, now we'll put that over there. So your argument is that under Washington law, there's an implied duty of good faith in every insurance contract, and therefore the good faith claim can't be resolved by Batdorf. Is that right?
That's very correct.
Okay.
Yes, Your Honor.
And why wouldn't, if you're correct, why wouldn't we then remand this to the trial court to determine whether there was good faith or not?
That's what we're asking the court to do. Yeah, is
decide that on appeal.
Right. I'm not asking you to.
So you're telling me all these bad faith things that happened, but those don't actually implicate what we have to do here, if your position is correct.
Right.
So you're, just to be clear, I think everybody agrees Batdorf at least gets rid of contract. They would say it gets rid of every claim, including bad faith or anything else. but at least contract. You say, no, we still have bad faith, therefore remand, let the district court decide. And come
Yes,
what
Your
may.
Honor. I'd like to talk a little bit
Anything more complicated about your argument than that?
a little bit with Batdorf, which I'd like to get to, but you're right. There were
Why are you trying to complicate it more than it is?
well, the contract language in Batdorf is not exactly the same as the contract language here. Here we had a combination of language talking about how in recognizing that the duties owed for benefits may not be extinguished just by paying the amount of the policy, because it contemplates paying on the duty to defend in defense costs as well. In Batdorf, we also didn't have a pre-suit, like many, many months before, claim for help. In here we do. So there's a timing issue on when did that breach occur, because here there were multiple requests for help from the insured saying at the outset, hey, we've got these neighbors coming on our
Let
property.
me stop. Are you saying there's a breach of contract?
I think
Still?
that I do think that there is that there can be grounds for a breach of contract under the
This
unique.
can be what?
Yeah, I think
What is your claim?
Yes.
Just so we understand it.
Yes, I think that here there is enough ambiguity and enough differences between Batdorf to send it back, because
On breach of contract?
yes, Your Honor, we had in Batdorf they made a claim. They went through and a lawsuit was filed against them. They were given defense by their insurance company. Partway through that defense, the insurance company retracted and said, here's your policy limits. Here, on the other hand, we had my clients saying, hey, we want help with this well before a lawsuit was filed. During that time period, First American created the need for an actual litigation defense in the first place because they're funding the lawsuit against my clients. My clients asked initially when there was a dispute over the scope of their title. They asked for help. At that point, I think the contractual duties were triggered for First American to act. Later, we get into, this brings in the bad faith issues. What did First American know? And this is stuff we didn't get discovery on, and I believe we should have. What did they know about the other landowners' claims? Why did they decide to pay our two clients' policy limits instead of giving them a defense costs as well, and put all of their insurers on equal footing? We think that there are reasonable inferences that the trial court ignored that show that First American acted in its own best interest and in a manner that would save itself money by doing so.
I just want to follow up on your answer to Judge McEwen's questions. You clarified that you're seeking remand on the bad faith claim.
Yes.
I now understand that you think there's a issue with breach of contract claim as well, but I'm talking about the bad faith claim
Yes.
for a moment. And the district court found no bad faith. He found that the policy gave First American the ability to make the choice it made, right? So in order to remand, we would need to say, as a matter of law, he was wrong about that. And you're talking about remand for the factual determination of bad faith? Is that what you're saying? Because he's ruled on the legal question, hasn't he?
The issue in this, and when I'm talking about bad faith, I'm really talking about all of the extra contractual claims.
My question is, if I didn't ask a good question, I apologize, but my question is, what is it you think the district court would do on remand? He's not going to revisit the question about whether this is bad faith as a matter of law, right? He would be looking for the factual predicate to make findings about the facts supporting the bad faith claim. Is that it?
We're asking for remand so that the whether First American engaged in bad faith goes to the jury. There's an
Okay, So let's break this down. The district court ruled on the bad faith claim as a matter of law, not fact, right?
Well, yes,
That it wasn't bad faith because the contract gave them the right to do what they did.
right.
So we would have to reverse that first, wouldn't we? I just want to make sure I understand what your position is.
Yes, Your Honor. And
Okay.
the tort duty of good faith is completely separate from the contractual claim. And the trial court erred in relying completely on Batdorf to determine that the insurance company acted in good faith and that it didn't act unreasonably.
I can take yes for an answer.
Yes.
I just want to make sure that that's what you're asking us to do, and I think you've answered my question.
Yes, Your Honor. Yes, Your Honor. And your earlier question about does the duty of good faith apply to title insurance policies, that answer is yes. And I've cited...
No, I didn't ask that question.
Okay.
But it's okay.
It does. And
Figure out how we get to bad faith where, and I'm looking for a comparable case law, and I think you've answered the question, where
Okay.
if the policy gives them the ability to do what they did, how we'd find bad faith as a matter of law, why the district court was wrong about that. And I
Yeah.
think you've answered that question.
Thank you, Your Honor. And that brings into play somewhat some of the other extra contractual claims, like the Insurance Fair Conduct Act violation claim. That claim requires a showing of an unreasonable denial of coverage or an unreasonable denial of the payment of benefits. And on the similar facts, the trial court erred in dismissing that claim, and it really didn't even touch on it, and just said, hey, we're looking only at did they have a right to exercise this contractual option? What insurance bad faith law does and what IFCA does, it requires an insurance company to act reasonably and to act in good faith and to put its insured's interests equal to its own when it's making those kinds of decisions. And our argument here is that the trial court erred in ignoring the fact that First American is the reason why they're here in the first place. First American ignored their request for help, then funded the lawsuit against them, filed the lawsuit against them, frustrated attempts to resolve the case early on by creating another easement. We're here today because First American missed this issue in their title policy, right? Which is okay. They're allowed to make mistakes, and that's a contractual issue, right? But we're not just talking about the diminution in our client's property value or how much that's worth, because that's the liability indemnity part of the policy. We've got the duty to defend, and any exercise of how they're going to handle this claim is governed by the overarching duty of good faith.
What did they miss in the policy? What's the mistake?
The easement, the purported easement.
I see.
And so that's not why we're here. So some of the case law we're looking that is in the respondent's materials is related to just that issue that, did they act negligently in doing that? That's not what we're here for.
I thought you were speaking about missing a provision of the policy as opposed to the underlying factual conditions.
Judge
Thank
Hawkins,
for
did
the
you have a question?
Clarification.
I did.
Sorry.
I was still talking. Go ahead.
Sorry.
Go ahead,
No?
please.
Oh.
I'm done. I'm
Oh.
good. I'm good.
You've talked about there is a body of bad faith law that deals with insurance contracts generally.
Yes.
Under Washington law, does that apply to title insurance?
Yes. Yes, Your Honor. The Coventry case, Tank, all of those apply. And I can tell you the cases that specifically talk about title insurance that are in our materials. Well, first of all, if you look at WAC 284-3310, which are our claims handling regulations, that talks about the definition of insurer that includes title insurance. The Campbell case, title insurance conduct is governed by the duty of good faith. The Robbins case, title insurer acted in bad faith. Rabinowitz, this is an unpublished case, but talks about how the duty of good faith informs every decision and all of the conduct an insurance company makes.
Why would we need to certify the question?
I don't think that the issue of bad faith needs to be certified to the Washington State Supreme Court. There are a couple of issues that we thought warranted certification. The issue of bad faith, I think, is very clear, and I don't think it warrants certification. But if there is any confusion about it, that could have happened. But the issues for certification that we requested were related to whether a title insurance policy is indemnity only, whether the court should treat this type of situation similar to Singh, which is a liability policy, in determining whether the duty to defend applies. And then the last issue is whether First American owed any duties to Stern in the context of insurance bad faith and the duty of good faith there, whether the insurance company owed any duties to him as the sole member of the LLC and the person who lived on the property and was dealing with the insurance company.
And to which the district court answered the proposition that the First American owed uninsured Stern some greater duty than he owed and insures Quilbillies is there's no authority for that.
This is an unanswered question.
It seems an obvious answer, however.
Well, yeah, Mr. Stern was not named as a named insured on the policy. That is
That's too bad for him,
Yeah.
but that's how insurance works.
That's true. And Mr. Stern is not claiming a breach of contract claim. He's claiming a common law negligence claim,
Right.
and that because this was in the claims handling arena, the duty of good faith applied to him as the person dealing with them and the person impacted by the decision. So I'll reserve my last 30 seconds. Thank
Okay,
you.
thank you. We'll hear from opposing counsel, please.
May it please the court, Brittany Pierce, counsel for Appellee First American Title Insurance Company. This is a case about contract interpretation and the long-standing case of Batdorf, which interprets the very provisions we have at issue here. The very provisions at issue here say that a title insurance company, and it is a title insurance company and a liability insurance company, when a claim is made, has a number of options. And one of those options is to accept the claim, accept coverage, and then to pay the policy limits in full, giving the insureds the benefit of their bargain. And doing so ends the contracts. And Batdorf upholds that as a provision that insurers can rely upon and can exercise in accepting their claims from their insureds, and that's exactly what happened here. Thereafter, once this was accepted, the insured said, we don't want this accepted how you accepted it. We don't like that you paid the policy limits. We want something different. But the policies do not require that. The title insurance policy states very clearly what the title insurer has the option to do, and that policy provision was exercised here, again, to pay the full limits. And now the insureds want the court to rewrite the contracts to provide additional benefits that are not allowed under the policy language itself and that are not allowed under Washington case law on title insurance policy interpretation.
Is it correct that your client is funding the lawsuit on the other side?
It is paying for insureds on the other side of the underlying litigation, all of which happened after election of the policy options in this case.
You think that does not change the dynamic at all?
I do not think it does change the dynamic here.
Do you agree that the principle of bad faith applies to all insurance policies in Washington, including title insurance?
I do think that there is an obligation of good faith generally for insurance, but we've got some specific answers here under Batdorf for title insurance policies.
And but Batdorf is not a title insurance case, is it?
Batdorf is a title insurance case. And under
but with a contract question, right?
It is a contract question. It is a title insurance case on a contract question, but its language does say that it ends all liability, and it is not specified that it is just contract liability. So the language itself is broader, as is the language in the policies we have here, that it does end all liability here. And bad faith requires more anyway. It requires something unreasonable here. And it's not unreasonable for a title insurance company to apply the terms of its policies, to make an election under that.
It may or may not be. I might agree with you, but there hasn't really been a finding on bad faith or no bad faith, right?
The trial court did make a finding that there was no bad faith.
Well,
as a matter of law.
As a matter of law, not as a matter of fact.
Correct. They made that finding as a matter of law. And that bad faith finding can be made as a matter of law here. Because bad faith, as I said, does require the insurer to act unreasonably or in some way that's unfounded.
Not really the basis for the finding as a matter of law here. I mean, isn't that the basis for the finding essentially that under Batdorf and the paying up, that any bad faith is basically subsumed under the contract claim?
I think it can be twofold. I think, yes, that is correct. Yes, under Batdorf, that bad faith can be subsumed under that because the language in Batdorf does apply to end all liability, even beyond contract liability there. And also, if you do look at what would bad faith even be, you can't have bad faith for exercising a contractual provision which has been upheld by Washington law under Batdorf.
Is that because you think that because the contract gave First American this option, that they necessarily didn't act unreasonably? Is that what you're saying?
Yes. When a contract gives you an option, you get to rely on the terms of the contract. That's what the parties bargained for. That is what insurance premium payment is for in this case. And so when the parties enter into a contract with set terms, and in this case, it gives various options. And when someone in a party to the contract, in this case, the title insurance company, is relying on those terms and then exercising those terms, then that is appropriate behavior. There's been no case law that says it's bad faith or not good faith to exercise a policy provision, to exercise a contract term.
I appreciate that there wasn't a finding on the facts about bad faith, and opposing counsel's clarified for me when she's seeking remand, she's seeking remand for that very reason. But I'm just wondering if you could circle back to Judge Hawkins's question about whether does your answer change at all on the facts of this particular case, given that there's apparently funding on both sides? How does that change things?
It does not change things. Every policy is considered on its own four corners, on its own merits. It's not unusual in the title insurance context to have a title insurance company insure multiple insureds in a subdivision, in a neighborhood.
That's true of all
That's-
insurance.
yeah.
True of all insurance, isn't it?
Yes, and so what that means is that you need to look at the policy before you. And in this case, the policy before the title company was the Quilbillies policy and the Fuller policy, and it made the determinations on those policies on those faces. It was many months later that a lawsuit was filed, and even months after that, before that lawsuit was tendered
I think
to the
that
title
answered
insurance company.
I think you've now answered the one question I had was, and when the Quilbillies parties approached your client, there was no pending litigation.
Correct.
Yeah.
It was many months later. In fact, I believe it was over a year later from the time that Quilbillies first approached First American that a lawsuit was filed in that underlying action.
And
But we have, oh, go ahead.
the plaintiffs in the easement action, if you'll allow me to describe it that way, also insured by First American. Was the policy similar?
I don't know about those policies, and those
Did it
policies
have-
are not part of the record.
Did it have policy limits?
I am unfamiliar with those policies. They haven't been part of the record in this case, and they don't need to be part of the record, and they don't need to be part of the consideration when what the
They
first...
are not. Just to help me understand the case a little bit better. Did when the easement people apparently approached the title insurance company, correct?
I am assuming at some point that did occur, but what we have here is decisions
And
made
I'm
before
assuming
that.
asked them to fund the lawsuit, the easement lawsuit, correct?
I would presume, but again, that happened after, what we have here, which is
And we
when...
don't know whether that insurance policy allowed First American to do exactly what they did to Quilbillies.
That's correct. We do not have that information on the record before us.
So my question then is that the argument you're making that basically it's per se reasonable to exercise the contract claims as you did, that was rejected in Singh. I recognize Singh is a liability case, not a title case. But you're basically asking us to assume, I guess, that Batdorf answers all questions.
Batdorf does answer all the questions for title insurance here on the
Even
questions before court.
Even the good faith question?
I believe that Batdorf does answer those
And where
questions.
in Batdorf would I look to find that answer?
I think it comes back to that language that the policy exercising the provision ends all liability.
So this
and
it's the
that's
all
language.
liability question
It is.
statement in Batdorf that you rely on.
Yes, it's
And
the
if
by
we
paying
were
up.
to determine that the good faith is not subsumed under that, and that that's really just a pure contractual matter, then would you agree that there's been no finding here of bad faith or not bad faith?
I disagree that there's no finding of bad faith, again, because the trial court found no bad faith.
As a matter of law.
As a matter of law. And I think, if I'm understanding correctly, you're asking about, but the factual
Is there any
basis.
factual determination as to bad faith?
The trial court did not, to my recollection, lay out a factual basis for finding no bad faith in its decision. But I do think that given what the bad faith is based upon and what the language and the requirements are that you cannot have that as even a factual basis.
Quick pay
based on
up
that.
and then later have this lawsuit.
Well,
That's
and so
okay.
here they did pay, and months later a lawsuit was filed. And what a title insurance company does is looks at what's before it at the moment in time, and it has to make a decision. It had options of, do we just want to pay a diminution in value, for example, pay some loss under the policy? And instead, what it did was it responded to these insureds and said, this easement that you're coming to us with wasn't accepted from the policy. we are going to elect one of our options, which is to pay the policy limits. And at that moment in time, there was no pending lawsuit. There was nothing that was being filed by the other neighbors at that moment. And so the title insurance could rely on the terms of its policy, make a decision based on the information it had before it at that time. And that's what it did.
Let's just assume hypothetically that a lawsuit was extant at the time the Quilbillies came to your client. Could your client have undertaken the defense on behalf of the Quilbillies?
Undertaking a defense is an option under the policy, but it's not a required option.
I understand.
And so here it chose something that was a benefit. The insureds got the full value of their policy before any lawsuit was filed. And they had the option. They could say, you're right, this easement maybe doesn't look so great. Let's just take the money and agree that the neighbors do have an easement. They could have sold their property. They had options at the time once they had been given their policy limits.
Did the title insurance, did your client know who the people claiming the right to easement were?
I do not know if they knew at that time, and that's not part of this record. And I don't think that it makes a difference at that moment in time, even if they did know if there was, there were claims on both sides, because they have to, look at every contract individually, treat each insured individually. And that's what they did here. And that's what the information is here in paying the policy limits.
If it was present at that time, your client, the title insurance company, could have said to the Quilbillies, here's the policy limits, you're on your own, but said to the people who are claiming the easement, we're going to fund your lawsuit.
It can do that.
And that's not bad faith.
That is not bad faith. It all comes back to the policy provisions and treating your insureds appropriately under the terms of the contract that the parties bargained for.
And
the contract terms.
What I've just described, was that apparent to Judge Settle?
It was raised before Judge Settle, the same basic facts that are before this court. That yes, it was raised that First American did have insureds on the other side of the underlying easement dispute.
And
so that
was
before
funding the
court.
lawsuit.
I believe that fact was before the court. It's all been on the same record
Okay.
as is before
All
this court. There's been no additional
Thank you.
record there.
Thank you.
And so just, I'm happy to answer any other questions, Your Honors.
Don't think we have any more.
Thank you. And then we just generally ask that the court affirm the trial court in this case on all grounds.
Thank you, counsel.
Thank you.
Batdorf does not address bad faith or extra contractual claims. The duty of good faith is separate from and in addition to anything related to the contract. It is actionable in the absence of coverage under ONVIA. It is separate from the duty to pay under Coventry. Laka Jaw, a title insurance case in the Western District, said even if the insurer reaches the correct coverage result, the insurer may still breach its duty of good faith in the claims handling process. That's what we're talking about here. Batdorf's disposal of all liability was only related to contractual liability. That's the analysis they were performing. You can't contract out of these duties of good faith, this duty of good faith. The concept that my clients bargained for this is wrong. That's the whole reason why Washington has this area of bad faith protecting policyholders and requiring insurance companies to treat them fairly and giving rise to these causes of action because they recognize the unequal bargaining power. They are vulnerable. First American made a choice. They could have made a more reasonable choice that put all of their insureds on the same footing. And Judge Hawkins, you talked about asking these questions about what did First American know about these other insureds? What were their policy limits? You take 10 policy limits versus 2. When did they first go to First American? Was it at the same time? Was it before they charged my client's property with guns? We don't know that because we didn't get discovery on that when we asked for it in responding to our summary judgment motion. But in your job in ruling on this is to look at it de novo and to make all reasonable inferences in favor of our client in determining whether there could be a record for the jury to find bad faith on these facts. And we think that there's plenty of evidence that it is there. We ask that the court do not extend Batdorf beyond its limited holding and beyond the limited language that is used there. Thank you, Your Honor.
Thank you both. We'll take that case under advisement.